Wow. Court does call the case. People versus Paris Lester.
That's for people.
Emmett Powell with and on behalf of Mr. Lester, can you say your name for the record?
Paris Lester.
Thank you.
Your Honor, we are going to be requesting an adjournment to review discovery.
Probable cause conference will be adjourned 5th, 2025, 9 a.m. Fine.
Thank you.
Court calls the case of the people versus James Harbin.
People.
One Brown, Deputy Chief Public Defender, appearing on behalf of Mr. Harbin. Mr. Harbin. He's at St. Joseph
Hospital. Correct. I changed his. This was the one I changed his bond on. I don't know that we have a indication, but what I will do is I'll adjourn it to the 12th. Let's see where everything is at.
Thank you.
All right. June 12th, 2025, 9 a.m. Bond. Court does call the case of the people versus Germond Matthews.
First Assistant Public Defender Queen Anderson on behalf of Mr. Matthews, who's approaching. State your name for the record, Mr. Matthews.
Matthews.
Thank you. You're requesting an adjournment.
Yes, Your Honor, we referred this to the investigator. I did hear Your Honor give the co-defendant June 12th.
Will that work?
That should be
So
fine.
the co-defendant was,
Yes, Your Honor.
all right. Probable cause conference, June 12th, 2025, 9 a.m. Bond continued.
We'll come talk to you before this stuff, okay, but call me or Monday, once you know what happens.
Court does call the case of the people versus Jennifer Jones.
Hello, Your Honor, I'm sorry. Can you hear me?
Yeah, we can hear you.
Okay, cool.
Assistant Public Defender Natalie Pate with and on behalf of Ms. Jones, who is present via Zoom. Ma'am, can you please state your name for the court?
Jennifer Lee Jones.
Thank you, Your Honor. At this time,
She's upside down, but that's okay.
she is, but she's here.
I don't want to lose you.
Your Honor, at this time, we would request to set this case for preliminary examination. I believe discovery is complete.
You believe, okay.
I'm sorry, Your Honor, I didn't know how to fix it.
You did not what?
I didn't know how to fix it to make me go straight.
No, you're okay. You're okay.
I'm sorry.
No, you're fine. You're fine. We'll be able to deal with it. Miss Pate is just happy you're here.
All right.
Okay.
This is my first time on Zoom.
Yeah, I wouldn't know it. You're just such a pro at it. You're doing well.
I'm upside down.
Yeah, I know. It's okay. It's okay. Will the people have their witnesses available on the 3rd or what? What's the date? The 5th? Yes, the 3rd.
We'll do our best, Your Honor.
Preliminary examination in person, so you don't have to do this again. June 3rd.
Okay, I gotta go there because I live in Flint. June 3rd.
2025.
Uh-huh.
That's 9 a.m. That will be before Judge Perry.
All right, cool.
All right, yes. Your bond will continue, okay? Miss
All
Jones,
right.
you have a great day.
You have a blessed day too. Holla at you.
Bye-bye.
Thank you, Ms. Jones. Thank you, Your Honor.
All right.
Okay, so everybody else is in. Court does call the case, people versus Jacqueline Murray.
Your Honor, Assistant Prosecutor Victoria Clark here is here on behalf of the people.
Emmett Powell on behalf of Miss Murray, appearing tomorrow morning. State name for the record.
Jacqueline Annette Murray.
All right.
Your Honor, at first we were going to adjourn to try to get her released into treatment, but I talked to the prosecutor and we have come to an agreement that we believe it's best for her to get released into treatment. If Your Honor would grant that, I did send Anne a stipulated order if you need that. Otherwise, we can just adjourn it to get that order in.
What?
We're trying to get
You're
her.
trying to adjourn it. You want me to make a condition of her bond that she be released to treatment?
Yes, Your Honor.
Okay.
Yeah, we don't need to adjourn it. Unless Your Honor needs to adjourn it.
And we're off. Case number 1. Always watch how quickly these hearings start. It may sound routine, but every word here sets the legal chessboard in motion.
Thought we could do it today.
Do what today?
Modify her bond conditions so gets released into treatment. Oh, the case we are adjourning.
You're adjourning. Okay, how much time did you need?
Couple of weeks, Your Honor, please. Thank you.
You're just parroting what Bellinger's saying. It's okay. It's okay. Probable cause conference will be adjourned June 5th, 2025, 9 a.m.
Thank you, Your Honor.
Bond, you're welcome. Her bond will continue, and I, of course, will sign the order for her to be released on a PR.
Thank you, Your Honor.
to treatment.
Thank you.
Thank you, Your Honor.
You're welcome. Court calls the case, People versus Emmett. Oh, well,
No, it's okay. Ask me in a second.
yeah, I know. But Emmett Powell,
Assistant Public Defender Jay Bellinger on behalf of Mr. Pawa, who approaches. And Mr. Pawa, can you please state your name for the record?
My name is Emmett Powell.
thank you.
And Your Honor, we're just asking to set this matter for preliminary examination. Discovery is complete to the best of my knowledge.
People have their witnesses available on the 3rd. Preliminary examination in person, June 3rd, 2025, 9 a.m. before Judge Perry.
Okay.
Bond will continue. Thank
Can you
you.
touch okay? Okay.
Court does call the case of the People versus. You took my file. Dante Francis. Just one moment. No, that's not that person. Hang on.
Andrew Childers appearing on behalf of the people.
And Assistant Public Defender Tenazi Carey, I can really again, Your Honor, on behalf of Mr. Dante Francis.
All right. The record should reflect we had an in-chambers conference. I'm going to adjourn the probable cause conference based on that conference to June 5th, 2025, 9 a.m. Bond in this matter will continue. Thank you. Thank you, Ms. Francis.
Thank you, Your Honor.
Court does call the cases of the People versus Siobhan Vincent.
People, Your Honor.
There are how many cases? 1, 2, 3, 4.
Ready.
Good morning, Your Honor. Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Ms. Vincent. Ms. Vincent, could you state your name for the record, please?
My name is Siobhan Vincent.
Thank you.
Your Honor, today's the date and time set for, I believe, a competency review hearing.
Yes.
We do not yet have any updated reports. Does the court have a report?
I do not. I think the information that we had is that she was interviewed. They were accumulating the information and preparing a report. So what I will do in this instance is I'll adjourn this out, indicating that we don't have the report yet. But they did indicate that that report should be available soon. So I'm going to adjourn it to June 26th. We will move that date up if we receive the report earlier. June 26th, 2025, 9 a.m. Bond will continue as denied.
Thank you.
All right, thank you. They've got more. Who? Detlaps? I already called that, right? Yes. Correct. Court does call the case of People versus Benjamin Detlaps. This is a recall.
Assistant Public Defender Jay Bellinger on behalf of Mr. Detlaps.
Adjournments might feel like delays, but in the courtroom, timing is everything. What do you think? Are these just stalling tactics or necessary strategy?
Made day 890 out.
Mr. Detlaps, can you please restate your name for the record?
Yes, Benjamin David Detlaps, Your Honor. Detlaps.
And Your Honor, it's my understanding that the court is now in receipt of the competency evaluation and also the finding in order. I did indicate to the court via email that I did only include the case number that was indicated in the report itself for the finding in order. Would ask that that be signed and would also ask to address bond.
All right. I've signed the order. The defendant, after the court has reviewed the report, still remains incompetent to stand trial, but likely to obtain competency with treatment. And so the court will set the next review hearing for, August 14th, 2025, 9 a.m. as to bond.
Thank you, Your Honor. As to bond, Your Honor, my client has been in the Washington County Jail for the last 259 days. His current bond is set at $1,000 cash or surety and $1,000 10% on his respective cases. I have talked to my client. He advises that he can attend SMART recovery meetings at the Annex building. He has a local Ann Arbor address. He advises that he can get his medications there, that he can get his therapy there, that he can do drug testing there as well. He advises that he can attend that 3 times a week. My client also advises a more recent update with regard to his medical. He has a chipped tooth, Your Honor, that's causing him a lot of pain. He's asking for release so that he can get that taken care of with his own dentist, considering that he may be at a bit more of a detriment in terms of getting medical treatment for that within the Washington County Jail. I am asking that the court release him on tether. Home confinement would be okay in terms of flight risk, Your Honor. I don't know that the issue is necessarily flight over potential dangers of the community. I do believe that that would be alleviated with a home confinement tether GPS for tracking purposes so that he can go and start taking care of his mental health and his medical issues.
Response.
Your Honor, I would ask that bond remain as currently set. The defendant's charges are all basically for assaulting police officers and correction staff. The defendant is currently incompetent but restorable. If there was a very clear documented plan in place for the defendant to address his mental health history if he was out of the jail, that would be something I would be more amenable to. But I think the best place, unfortunately, for the defendant in order to regain competency and make it so he's less likely to reoffend is to stick with the current plan, have him receive the treatment from the CFP and hopefully regain competency in a short time.
Your Honor, to that, my response would be that I will be in contact with Sarah Stewart from CMH so that I can see about working on a treatment plan for him, and then I will file a motion with the court so that we can readdress this at a different time.
All right. And I'm not going to do anything unless I can see a plan for this.
Okay.
So the motion for bond modification and reduction is denied at this time.
Thank you.
All right.
I'll be in contact with Sarah and we'll see about getting a plan started, okay? All right. Thank you, Your Honor.
Thank you.
Zoom court upside down. This is the reality of post-pandemic justice. Serious cases, but sometimes with a little accidental comedy. Imagine pleading your case while flipped like Spider-Man.
Court recalls the case. Hang on. Gotta make sure I see the name. Tequila Evans guy.
Karen Dadush on behalf of Ms. Tequila Evans Gayan.
State your name, please.
Tequila Evans Gayan.
That's it. Go ahead.
Your Honor, the prosecution has offered that Ms. Tequila can plead to an added count 2 attempt resisting police officer with no objection to HIDA with count 1 dismissed. Here's all the forms.
All right.
R.
And that's a guilty plea?
Yes, sir.
All right. The plea form the court has in front of it is indicating that she would be pleading to attempted resisting and obstructing a police officer, the 1-year misdemeanor. Upon her successful guilty plea to that charge, count 1 would be dismissed, and there's no objection to HIDA. That's the court's full understanding of.
Yes, Your Honor. Yes, Your Honor. And for the record, we are going to be requesting that she gets this under HIDA.
Pardon?
We're requesting that this be under HIDA. I don't know if I had to say that on the record.
Didn't you already say that?
Well, she has no objection to HIDA. That doesn't mean I'm requesting it.
Anything else you got?
Nothing else.
All right, I'm gonna talk to Tequila now. Can I have her sworn?
Raise your right hand. Do you solemnly swear in the firm the testimony you're about to give the truth, the whole truth, and nothing but the truth to help you God? State your name.
Tequila Evans Gayan.
All right. Ma'am, it is this court's understanding that you are going to be pleading guilty to an added count 2 of attempted resisting and obstructing a police officer. That's a misdemeanor punishable by up to 1 year incarceration and $1,000 fine plus court costs. Do you understand that?
Yes.
All right. I further have to advise you that while I'm taking your plea, I would not be your sentencing judge in this case, and you would be sentenced before Judge Washington in the 14B District Court. You understand that?
Yes.
Understanding all of that, you still wish to plead guilty? And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights? Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Oh, that's the same thing. I read.
It's the same thing, actually.
Yes.
You understand you're giving up your right to appeal of right. Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily of your own free will?
Yes.
And because you believe that you are indeed guilty of this offense?
Yes.
January 20th, 2025, at the location of East Clark Road near Centennial Avenue in Ypsilanti Township, Washtenaw County, state of Michigan. Did you come into contact with Washtenaw County Sheriff deputies?
Yes.
What happened?
They basically told me I swerved, my tail light was out, which it wasn't. But I guess they're allowed to do that because I guess there was a phone call in the area that basically there was some stuff going on in the area. So they just wanted to make sure it wasn't me. They seen me with a nicotine breeze. I didn't know that we could be detained for that. So I was kind of scared when I seen 6 police officers, and then they were trying to tell me to get out the car, but I didn't know I could be detained for a breeze. So I was resisting, and then they placed me in the car and basically told me, oh, okay.
So you resisted and obstructed them by not exiting your vehicle upon their request.
Yes.
Is that correct?
Yes.
All right. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes.
Defense is satisfied, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing in this matter will be
July 10th at 10 a.m. with Judge Washington.
July 10th, 2025, 10 a.m. before Judge Washington. Bond in this case will continue.
Thank you, Your Honor.
Well, take care.
Thank you.
All right,
Say your
be
name
real.
4 times.
That's it.
That's it, you know?
Highlight. Mr. Cody Jolly was supposed to. They've never sanctioned an interference.
So what are all these smells? I've already called them?
Work that he. Yes.
Okay, we didn't have to say it that way. Court does call the case, People State of Michigan versus Cody Jolly.
Andrew Childers appearing on behalf of the people.
All right, Mr. Jolly is acting in pro per. Mr. Jolly does not wish to appear again.
The only update I have for the court is, myself and some colleagues have done some research about our case proceeding basically without the defendant.
Correct.
If the court wishes for us to go that route, my thought is that I would prepare a motion for this court to consider, and obviously we will serve it upon the defendant in the jail. But basically, if he continuing to make this what appears to be a knowing decision to not involve himself in the case, that doesn't mean that the case stops.
Correct. Okay, if you would file that motion, I'd
Yep.
certainly entertain it.
Okay.
Why don't I set a date for the I'll just set a date for the motion, which will be the same adjourned retrial. Can we get it in with adequate notice, say within, so I can hear it on the 12th?
The 12th would be perfect. That's
All
fine.
right. So I'll adjourn the probable cause and the motion to June 12th, 2025. I'll make that at 3 p.m. since we'll be dealing with the motion. Bond will continue.
Thank you.
Thank you.
Your Honor,
Oh, no.
on a non-case related matter.
Yes, ma'am.